everyone. My name is Todd Richards, and I'd like to welcome you to today's webinar titled Training for Guardians and Trustees of Minor Children. In order to minimize distractions and background noise, everyone is attending today's call in listen-only mode. If you do have a question during the live presentation, please type it into the panel designated for questions. The image currently on the screen shows you how to do this. We will pause at various times throughout the call and try to address as many questions as we can. So with that, I'd like to turn the call over to Bobby Fazy.
Thanks, Todd. My name is Bobby Fazy. I'm president of Insight Law, and I'm an estate planning attorney. And as Todd said, this program is titled Trustee and Guardian Training for Clients with Minor Children. This program, the goal for this webinar is to provide education and resources for our clients and their helpers in dealing with minor children in the event of disability or death. What I mean by helpers is in an estate plan, we're providing for contingencies in the event of disability or death of our clients, and they're going to need people to assist them with certain roles. And this program today will go ahead and describe those roles and hopefully make it give you some more comfort in what your role would be, or if you're a client, on what the roles are laid out for in your planning. So with that being said, if something does happen to a client, and if you are a trustee or a guardian or have been named that, then, or even a spouse of a client, the first step in any of these situations is to stop and call the law firm. We have done this before. We have a lot of resources, and we'll help guide you and assist you through the process legally. Our phone number I've laid out there on the screen. We also have a website that'll be also posted later on, but it's www.insightlaw.net. But number one is we have a comprehensive approach here at Insight Law, and our goal is really to make life a little bit easier for the family during a very difficult time. So with that being said, I'm going to give you a brief overview of estate planning for those of you who are not familiar with it if you're a helper, and what we're trying to do here, and kind of back in that way, and then we'll get into the various roles. And the easiest way that I find to explain what we're trying to accomplish on the estate planning side is I consider it the snapshot test. And what I mean by the snapshot test is I ask my clients to envision a time after they've passed away, and the joke is we have all of our clients look down from their cloud from above. They don't look up. Beats the alternative. But if people are doing what you thought they would be doing, and the care for your minor is the way that you thought it would be doing, and money is being handled the right way, they're being raised the right way, or the way that you'd want them, then that's a plan that worked. If it's not, if money's not being used the right way, or they're not being cared for the right way, maybe there's too much court involvement, normally that's not a plan that worked. And our goal is to help our clients try to get that snapshot as clear as they can in their mind. And it's a difficult exercise because we don't really want to think about that time, care for our children, and we understand that we have to plan for these types of contingencies, and that gives us the peace of mind to offer this type of planning. So with that kind of snapshot in your mind, from an estate planning perspective, I wanted to just give you our definition of estate planning so you know what the core concepts what we're trying to achieve. The first part of the definition is I want to control my property while I'm alive and well. Our clients definitely want a high degree of control of their plan and of their property while they're alive and well, and that's definitely what we seek to achieve. The second is a plan for me and my loved ones if I become disabled. And I think a lot of people miss this one, especially with parents with minor children. Let's say there's a car accident and both parents are disabled and not able, and we're talking mental disability, not able to mentally manage affairs. Then although there's not a death, we still need the kids to be taken care of. And so there are steps and procedures that we follow to make sure the kids are taken care of in a disability situation as well. Continuing on with the definition, we want to then give what we have to whom we want, in the way that, when we want, in the way that we want, all while assuring my wisdom is transferred along with the rest of my wealth. So really that second half of it is how are we going to use the money, and to who is the finances and the wealth going to be transferred to, and how are the children going to be raised along with values that you're trying to pass on. So with that core definition of estate planning, the role of the guardian, and I start with the question, is what's the number one fear of parents with minor children? And overwhelmingly, it's who will care for my children in the event of my death. And the role of guardian there's two main roles when it comes to minor children and how we handle it. One is guardian and one is the trustee. And the role of the guardian, if you've been named a guardian, is the primary duty is to take custody of the minor children in the event of the parent's disability or death. You are the person in charge of the kid's physical well-being. Handle the living arrangements, the day-to-day care and decision-making, health care decisions for the kids. You do not have any specific financial authority if you are named solely the guardian. The guardian is where the kids physically reside. And so that's the number one point that we want to get across there. And who can legally nominate guardians? In most states, and in the states of our clients where they reside, it's the biological parent or the current legal guardian. And so that's just a little background for you. How can guardians be nominated? States vary, but basically it has to be signed and in writing, and it's traditionally done in the will. And so I'm going to give you a little bit of background on how that would work. So if client passes away, let's say both husband and wife pass away if we have a married situation, then and we'll have the guardian will be nominated in the will. The will is held at the law firm safety deposit box, so you don't have to go trying to find out where the will is. And we will assist you. So the main thing is contact us, and we will get you appointed through the probate court. We will schedule the appointment, and we will handle all the logistics on that end. But if you're named in the will as the guardian, contact the firm. We've got the legal document. We'll we'll schedule the appointment with the court. That usually takes a little bit of time because it depends on how the court schedules work, and so there could be a time lag. It could be a few weeks. And so what happens during that interim time before you get to court? Where do the kids reside? Well, we don't want the kids to be placed with Child Protective Services. So what we've done is we have what's called an appointment of interim guardian form. It's a legal document that lays out those contingencies, is what happens before that. So I'm going to show you a sample of this appointment of legal guardian, interim guardian form. So as you can see here, I'll try to maximize it a little bit more. As you can see here, it basically states that, hey, we've laid out and we've created a will and we've named a guardian, but in the event both of us are deceased, we recognize there will be a short period of time before the probate court can appoint a final guardian for our minor child. For this reason, we have created this appointment of interim guardian. Accordingly, this document hereby authorizes the following named individuals to serve as interim guardians until such time as the probate court appoints a final guardian for our minor child. So with this document, this normally allows us to cover that little lag of time until you get a formal court order appointing you. The other legal document that we use to assist in this situation is a durable power of attorney for child care. The durable power of attorney for child care serves a couple purposes, but one of them is the fact that you would be able to take temporary custody of the child until the court appoints you. It also allows the agent or the guardian to deal with any education, deal with schools, deal with any medical issues for the children. So we think it's a great document, and it covers a lot of those gray areas. We also have this child care power of attorney if our clients are going away on vacation, and if they want to appoint certain people during that period of time, that could be done in that document as well. We've also asked our clients to complete what's called a medical history summary for our children, for their children. If you are a client and have not done this, it's not required, but we always find that more information is better than less information. So if you haven't done it, just contact the firm, and we will go ahead and get a copy out to you. So that is the interim guardian procedures. That's the appointment of interim guardian form and the child care power of attorney / financial power of attorney for the child. So key is normally if you are a guardian, you're going to be appointed in what's called the last will and testament. It's actually a pour-over will in our firm, and I'll explain how that interacts with the other legal documents. But within that will, which is held at the law firm, we've laid out who the guardians are. Contact the firm. We'll get you scheduled with the appointment. In the interim, we will make sure that you have the legal documents to be the interim guardian for the child and have all the necessary powers on that end. All right. Now, that is the guardian, and that's the role of the guardian, and there's where physical custody of the child will reside. The trustee is going to be dealing with the financial aspects of the situation. They handle all the money. So I'm going to go through what a trustee does, but to back up a little bit, you need to know what is a trust, and then we'll go through what does the trustee do. So our clients, majority of our clients, we use what's called a revocable living trust, and that really serves as a will substitute for their planning. It's written for the helpers, and what I mean by the helpers is the trustee. It's not written in fancy legalese. We try to make it understandable, and it contains many personalized provisions. And so let me explain how a trust works in big picture format. So think of a trust as nothing more than a box. The box is basically laid out in the center of this picture. And we will put all of our clients' assets, basically we'll put them into the box, or we'll make them the assets payable to the box. And on the outside of the box, we have all these instructions. Okay, if I pass away, if I become disabled, I want the money to be used for my children in this specific way. And I will go through the document that the clients have prepared so that you're aware of how the money should be used. But basically, if we have everything in this trust or in this box here, then if something were to happen to our clients, then a court proceeding wouldn't be necessary for the next person in line to be able to manage those assets. We have a very specific procedure that we follow outside of the court proceeding that we can document, and we've got a specific successor trustees that are listed that have the authority and control to manage the assets, the checkbooks, and the like. So we put everything inside of the trust, the box. The trustee is the person who is in control or manages the checkbook or manages those assets within that. The benefits of a trust, avoid, number one, in a situation where we have minor children, it avoids court and court accountings if structured properly. So the court's there to protect the children, but a lot of times, in my experience, clients know who they want. They trust. They pick people that they trust. They've laid out how they want the money to be used. If we have to submit an accounting every time we want to use money for the kids, it becomes expensive, time-consuming, and the funds that should be used for the children are being eroded in the court process. So the benefit, one of the main benefits of the trust when we have minor children is we've basically created our own court, and we've laid out our own instructions and say it's great if the court's there if something goes wrong, but let's do it. This is the way that we like to have things handled. Also, the trust maker can dictate all the terms rather than a judge. So including the length of time to leave the assets in the trust and the terms under which the assets may be used and withdrawn. Normally, if the court was overseeing it, once the child reaches 18, then they would be able to have access to the money. They would be the age of majority. And a lot of times that may not be exactly what the clients want, especially if there's a big pool of life insurance money coming in. Could be several $1,000,000. The other benefit of a trust is that it may be modified if things change. If you recall, what we've created is a revocable living trust for our clients. So if things change over the years, the kids are getting older, or maybe guardians or trustees move, we can easily update the terms of the trust and put them into play. So a lot of great benefits. Benefits continued for the trust is if, as the kids get older, we can put these great provisions in the trust to potentially protect their inheritance against bad marriages, divorce. If the kids have creditors of their own, God forbid the kids had a catastrophic illness or in a special needs situation, it would be a situation where we could have those funds available to supplement government benefits but not replace the government benefits. And then the last point is to protect the kids from themselves. It could be a lot of money that we're dealing with, and I've seen the situations where that can hurt more than help if it's not planned properly as far as the investments are concerned and how the money should be used. So a lot of great benefits to the trust. I just wanted to give you a big picture overview of that. And then with that being said, the role of the trustee now is very important. If the child is a minor, generally speaking, under all states' laws, a minor cannot own assets and therefore can't receive an inheritance outright. Can't give a 13-year-old a $100,000 life insurance check. So if we didn't have the trust, we would have to go and have the court oversee it. But instead, we have the trust. We have that listed as a beneficiary, and the trustee is the individual who's in charge of all the financial decisions and controls the checkbook. Okay, so we've got these two roles that are out there. We've got the role of guardian, which is where the child physically resides, and then we've got the role of trustee, who is handling the money. And both, the trustee is has a fiduciary duty, and it's a very important duty. You shouldn't take it lightly. Your fiduciary duty is to manage those assets on behalf of the children, on the beneficiaries, and act in good faith. And I'll show you how our clients have laid out those instructions, but it's something not to take lightly. And the main thing is that you always want to be looking out for the best interest of the children, and you have a fiduciary duty, and you cannot. You got to be careful as far as making expenditures for what's the personal use versus use for the children. And so really we always want to keep that hat on, and when we go through this counseling with our clients, they do not take this decision lightly. And if you've been named a guardian or trustee, they've named you, they've gone through this and thought about it, and they believe in your child-rearing philosophy, maturity, your age, patience, willingness to serve, social and moral habits and values, religious preferences in some instances, marital or family statuses, integrity. Okay, and so this is something that the clients feel there's no one who's going to be as good of or be able to replace them, but you are named as the next people in line, and they trust and entrust their children and their finances to you. And so our goal here is to show you what your role is and to provide the legal mechanism to hopefully get you through this without little of a legal headache as possible. Continuing with the role as the trustee is, well, what happens when the child reaches 18? And that's the age of majority in most states. In Virginia, it's that age, and so Virginia, Maryland, D.C. Do we normally turn over a checkbook to the 18-year-old? It could be millions of dollars. And so I find it in rare instances that is not normally the case. And so I want to introduce you to the concept that we've developed here. It's called an Introduction to Trustee Training. And basically, if you recall, all those protections that we have built into the trust, divorce protection for the kids, creditor protection, investment assistance, all those protections will stay in place as long as the money stays in the trust. Once we start taking the money out of the trust and maybe putting it into personal bank accounts and things like that, then we lose those protections. And so the whole idea is we are big believers of lifetime protective trusts at Insight Law, and it's not about not being able to access the money. It's about protections and developing time frames to access the money. So we've got this kind of lockbox that's always out there, and then we go through this analysis with our clients on, okay, how do you feel about when the children can start managing the money for themselves? While the money is always being held in this lifetime protective trust, or at least they understand the benefits of it, and then you can give them some access and control over it. So let me give you the example. So this is just one. Every client has different age groups, but let's say the child is younger than 25 years old. Then if you've been named the trustee, a lot of times we'll say the trustee alone will make all financial decisions for the child. From ages 25 to 35, then the child or the beneficiary and the trustee can be co-trustees and work together. And so the trustee would have to be able to sign off on items. If the beneficiary wanted the Porsche, well, the co-trustee would have to decide whether that was what mom and dad wanted and was their wishes. So we've got this kind of training period to give them the benefit rather than just, here's some money, good luck with it. And then after the age of 35, then the beneficiary and a co-trustee of their choice. So that at that point, the kids now can control who they want as their co-trustee, and it just depends on the counseling with our clients. It could be their college roommate, and so if that's the case, then they have a lot more degree of control over the finances. But as long as we have it in this lifetime protective trust, we've got a higher degree of protection. So that's just a big picture overview of how the trustee training works and why we've developed that type of approach. It's really critical that the guardian and the trustee interact or have a good communication protocol. This is teamwork. And so in every good team that I've been on, we need to communicate, and the guardians and trustees need to work together to achieve the common goals, right? What is best for the children, and what do the parents want for their children? If the guardian and the trustee is the same person, then that kind of solidifies things. But normally we counsel that we would want a guardian and then a trustee. That would serve as checks and balances, and it serves a lot of good purposes because it also protects the guardian from gray areas. Do we need to buy the bigger car or the minivan, or do we need to build an addition to the house or buy a new house? So if there's a third party there, if there's another trustee, they can balance those types of issues, and you just need a good working communication on that end. Also, if you're the guardian and let's say the child wants the fancy Porsche or Lamborghini at 18, well, you can take a lot of that pressure off by deflecting that. That's the third party's role. That's the trustee, and the trustee has to follow your parents' guidelines and wishes on that end. So a lot of good reasons why we like to bifurcate the role of guardian and trustee. But the main thing is you've been named in this position because the parents trust you, and you need to work together on this. And our goal is to facilitate that communication between you. The best way to facilitate that communication is we have our clients create or complete a checklist that we've created. It's called a letter of instruction to guardians and trustees. And this is a checklist, and it's a guide for our clients. It sets forth the specific instructions. We're going to ask you to review that, review it now and discuss with the parents so you understand their wishes. So if you don't have it, I'm going to show you a sample of it. And if you don't have it yet, you can contact the firm, and as long as we get the appropriate approval from the clients, we'll send it to you. But the letter of instruction to guardians and trustees is a form that looks like this, and it lays out the client's education preferences. In some instances, the clients will like these, or they'll add their own wishes. It's serving as a guide for you, okay? And our goal is we're trying to document our client's intent. And as you can see, it goes into college preferences, if they get savings requirements, if there's qualifying grade requirements, family visitation. Maybe you haven't been named as a guardian, but the clients want you to be involved. Well, these are the areas where we want family visitation, supervision. If travel is important, we want to make sure that. Are there certain holidays that are important as well? Payments for the guardian, it's an important role. What can we use as a payment? That's just a separate stipend that's not part of just taking care of not the children's needs. Religious preferences, safety concerns, firearms, is that something that you're pro or con against? If there needs to be any type of grief counseling, budgeting instructions, financial instructions for the kids, given some financial investment instructions. So you can see here we're trying to give, try to be very broad and give the clients a guide on that. In some instances, even our clients, we do some short audios, and we have the clients document their intent on the audios. Clients, if you have not taken advantage of that, you certainly can. That's part of our annual maintenance plan services. You just can call the office, and we can schedule that. We can even do that over the phone if that would be easier for you. Again, the whole point is to get document our client's wishes, the parent's intent, how the kids should be raised, why they wanted certain items, and so that we've got that, and the trustees know, and the guardians know. And I find with clear communication, it really just makes life easier for everyone. So if you are a guardian and a trustee and don't have this document, contact our office, and we'll send it to you. Our phone number is laid out on the screen, and also our email. You can email Jessie Norrington, who would handle this. She's our associate attorney, and she would get you the necessary documents. Her email is jkd like dog @insightlaw.net. Before I kind of summarize items, I'm going to let Todd take over and see if there's any questions that you have, and we'll get into those.
There are no questions right now. Remember, if you do have a question, to go ahead and type your question into the box in the side.
Okay. Well, I'll continue to talk kind of slowly going through this, and then we've got a few more minutes to go through. I know I documented a lot more time, but I think we've covered the main issues. But just to give you an overview, the summary of the legal documents that you need to be aware of if you're a trustee or guardian is you need to know what a revocable living trust is. And as I stated before, the trust is basically a will substitute, but it has a lot more protections, and we create it during your lifetime. And that's where the money will flow through, and the trustee of the trust is the person responsible for managing the finances on behalf of the children. The pour-over will, and it's called a pour-over will because everything, if we do everything right, everything is put inside of the trust. The pour-over will is named that because if something is left outside of the trust, those assets that are left outside of the trust will get poured into the trust if there's a death. The good news is it will eventually flow through with your instructions. The bad news is those assets that we left out of the trust will have to go through the court process or probate process, and that's one of the big benefits of a trust. Our clients don't want to go through that, and so we want to make sure all assets are titled there. But the second issue with the pour-over will is we will have list the guardians there, because the courts do want to see the guardians at some point, make sure that they don't have there's no criminal records and that they are of good character. And so you do have to get qualified before the court at some point if you're a guardian, and the pour-over will is the legal document that we utilize to manage that. The appointment of interim guardian form is what we use until you do get appointed, and that would provide the guardian with the legal authority to take the child to school or have physical custody over the children until we get a formal court order in place. The child care power of attorney is a great tool that we use. It could be used even if in there we list appointment of interim guardian, but if, let's say, the clients just go on vacation and don't take the kids, they can leave the child care power of attorney with the appropriate people, and they will be able to talk to health care providers, education providers on behalf of the parent with regard to the children. And then one of the biggest and most important forms is, I would say, the letter of instruction to guardian and trustees. So if you don't have that, it haven't been given that by the client, I would get that. And besides the fact of just reviewing it, I think the real value in the letter of instruction to the guardians and trustees is just have a conversation with the parents and kind of go through those issues. I find a good conversation goes a long way. And again, they've entrusted you for an important role. I think this is a very positive item. Hopefully, this will never have to kick in, but at least it gives us a peace of mind. And on our side, on the legal side, we've got a plan for contingencies, and so we want to have the plan up and running, and ready to go tomorrow. And so we want to make sure that there's an action plan in place. Other point I wanted to raise to you, or the other item I wanted to raise to you, is what we have is called a DocuBank Minors Matter card. And the purpose of this card, it provides easy access to child health care documents when you're not able to take your child to the doctor. And it's usually given to relatives, nannies, neighbors, and babysitters. So let me kind of give you an idea of how this works. And if clients, if you don't have this we have, it is a new service for us, so some of you may already have this. If you have it, if you don't have it, let us know. We'll get it. But the Minors Matter card is similar to the DocuBank card in that it will store all of the child care legal documents online, and then you will get a credit card for that, and or the child care power of attorney. So let's say that if you were to go on vacation, instead of having the child care power of attorney or the letter written that gives the nanny or the relative the authority to talk to the doctors or the education providers, this card will store them digitally, and then the card says dial this number. We'll fax those documents to you, or they can just pull it up offline. It'll show you how to access those documents online. So you just leave the card with those people, or you let the people know where those cards are at, and that makes things a lot easier. It's called a Minors Matter card, and just showing you the people that normally have you received these are either babysitters, grandparents, nannies, neighbors, aunts, uncles, and also the card will also notify you if your child has been taken to the hospital. You will be listed as an emergency contact, and you will be either called or emailed, contacted as immediately, and to let you know what the status is on that end. The service is 24 hours a day, 7 days a week, 365 days a year, and our goal here again is to make life a little bit easier, administration a little bit easier. It keeps you informed, gives you some worry-free travels for you. If you do not have this, then let us know. And also you can list the children's allergies, medical conditions. So if that medical summary you didn't complete, let us know. Complete it again, and we'll put it in the file for you. And so again, Jesse Norrington will be be able to handle that and get that process for you. But we think it's a great service, and we'd be happy to lay that out for you. Okay, with that being said, I ask you to contact our office with any questions. Again, our website is www.insightlaw.net. All of our information is listed on the website. We will be posting this webinar on the website as a follow-up, if you have any questions on that. Make sure you understand your role if you are a guardian and trustee. Know where the letter of instruction is to the guardian trustee. And so with that being said, I want to thank you for your time. And if you have any questions, again, you can contact our office at any time at 703-654-6019. This has been Bobby Fazy. I'm an estate planning attorney with Insight Law.